Now, another thing that you have is that even if none of these things take place, you have the situation of an objective person looking at the judge and determining that the judge may not be fair. And here you're looking at a judge who may have been receiving these payments, although you're not fighting the county, but he hasn't been disclosing them. Under Code of Judicial Conduct 3E that we mentioned before, the judge has to disclose things whether they're relevant or not. So consequently, if the judge is not disclosing these things, but the judge has received these payments, the judge has engaged in a pattern of conduct which is a perversion and an obstruction of justice. Now, mind you, even though the judge has received retroactive immunity from criminal prosecution, civil liability, and disciplinary action for what he's done or she has done, they have not received any immunity from the obligation to disclose and disqualify themselves. So by not having done that, they are dealing in obstruction of justice, which can be a violation of Penal Code Section 96.5. This is another way to go after the judge to get rid of the judge. You can get rid of any judge on this. And if the judge goes in and strikes your complaint against them, then you take it up on a writ. Now, what can probably happen is that the judges are going to go against you. They'll probably strike your complaint or your motion, and the Court of Appeal will uphold that striking. You now come back when this takes place in your appeal, and you say that you've been denied due process by their having done this. And we come in to another thing, and this becomes what is known as the fraud upon the court. In California, we have a section called CCP Section 473D, and that is if there's a fraud upon the court, and it's called an extrinsic fraud upon the court, which means this is something that you didn't know about or the judge has concealed, then everything that the judge has done is void. Now, there's a difference between an extrinsic fraud upon the court and an intrinsic fraud upon the court. An intrinsic fraud upon the court is something that you have found out about and you could have brought up during the trial. An extrinsic fraud upon the court is something that you couldn't have found out about, or somebody has done something to pervert the judicial system. Now, it's this last part that we're dealing with. That's the perversion of the judicial system. And that is the part that we are dealing with when the judges are perverting the judicial system, because that becomes the extrinsic fraud upon the court also. So here, what takes place is that you move to have the judge's decision voided based upon the perversion of the judicial system. And that is another way to come at things. You can also do this if you have the extrinsic fraud, if your lawyer has done something against you or helped the other side, that becomes an extrinsic fraud upon the court. Now, perjury during the trial is not going to be an extrinsic fraud upon the court. So if somebody lied during the trial, that's not going to count. It's only these special things that are going to count. Now, there's going to be a difference in the federal system. In the federal system, you have Rule 60B. If the motion is brought within a year, it includes intrinsic fraud upon the court. So in the federal system, if you got any fraud upon the court, it's going to work if you bring it within a year. If it's greater than a year, then it's only going to end up being your fraud upon the court, which is basically going to be your extrinsic fraud upon the court. Now, if everything fails in the state court system, you can still go to the federal system if there has been a fraud upon the court. You can bring a case in the federal system coming up under your 1983, which is your denial of civil rights. So that gives you your package and the arrows in your quiver of what you can bring. The judges do not expect this type of thing to happen to them. And the reason is because in our three parts of government, executive, legislative, and judicial, the balance has existed because the judicial has existed to balance the legislative and the executive. But the judicial branch of government has taken it upon itself to insulate itself against any type of balance. And it has done that by giving itself judicial immunity through case law, and also in the case of SBX 211, the legislative branch has helped out by giving it legislative immunity. However, when they pulled this little trick on SBX 211, they forgot about other things that existed. Because SBX 211 is a state law. There are federal laws that say that when a judge takes a payment, which has been held, interestingly enough, to be a bribe, they violate what is known as the intangible right to honest services. That's a federal law. So when you violate that law, you're violating the federal law. So even though the judge has retroactive immunity under the state law, the judge doesn't have any immunity on the intangible right, under the violation of the intangible right to honest services. The judge doesn't have any immunity under the federal law of conspiracy to violate civil rights, or under any type of conspiracy to go forward and hurt a person who is either an informant or a victim. So you're looking at your federal laws, but you have a problem here. The problem is the federal prosecutors don't do anything. So essentially, what we're faced as individuals is we're faced with a system where our federal prosecutors are not enforcing the criminal law of the intangible right to honest services. They're not enforcing the federal conspiracy laws. They're not enforcing the federal laws that protect our civil rights. So we are left with being able to go after these judges by knocking them out one by one when we're faced with them in the case, or knocking them out at the ballot box. We are not out of the game. It is not hopeless. We have our 473D motions. We have our Rule 60 motions. We have the same type of methods of knocking out the federal judges under the Federal Code of Civil Procedure Rule 4, Section 455, which will knock out a federal judge who has an interest in the case. So we have all of these methods that we can use. Our option is to become proactive and to use each and every one of these methods. See, our system initially was set up with respect to the judiciary with a belief that the judiciary had integrity. But our founding fathers were very skeptical. And therefore, it was also set up that the judiciary may not have integrity, and we had to protect against that. So we are now dealing in those protections. Therefore, in the end, we the citizens had to be proactive, and today must be proactive. So in summary, it comes down to the following. Faced with a judge in the 39 states where there's an election, look to see who gave a contribution to that judge. Was it your opponent or his attorney? And then force that disclosure and get rid of the judge. Number two, if you're dealing in California, look to see if that judge got payments from a county, or if you're in another state, look to see who paid the judge, and then get rid of that judge. And look to see that pattern of conduct. If that judge is not disclosing this information, you have the Code of Judicial Conduct. And by the way, in California, the Code of Judicial Conduct incorporates the Federal Code of Judicial Conduct and the Model Code of Judicial Conduct of the American Bar Association. So you have a lot of, shall we say, arrows in your quiver. You have a lot of weapons to use, and you use them. I have two websites. There's the website called richardfinelaw.com, and there is also the website, the campaignforjudicialintegrity.org. And each of these websites will help you with some of the things that I have talked about.